అందరికీ శుభోదయం. Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. This video relates to condonation of delay, which normally we come across. Particularly, the government will be filing the appeals after 1,000 days, 565 days, like that. In my previous videos, I think about a year back, I told you that Tehsildar Mangalagiri, he was imposed a fine of 25,000 rupees for delay. Here, Honorable Supreme Court of India, 2 judges bench, they hold that no doubt limitation should be there and undue delay should not be accepted. But if there is material fact, if the issue of law has to be settled, then the delay can be condoned. This is the important aspect. సహజం డిలే అయితే ఒప్పుకో, టెక్నికల్ కూడా తీసేయచ్చు, కానీ దానిలో ఇంపార్టెంట్ ఆస్పెక్ట్ ఆఫ్ లా ఉంటే అతనికి వార్నింగ్ ఇచ్చైనా సరే దాన్ని అలౌ చేయాలనేటువంటిది గౌరవనీయ సుప్రీంకోర్టు వారి ముఖ్య ఉద్దేశం. జస్టిస్ సుధాంశు ధూలియా అండ్ అహసానుద్దీన్ అమానుల్లా in the case of Inder Singh versus the state of Madhya Pradesh. Inder Singh versus the state of Madhya Pradesh, civil appeal number SLP అన్నాడు 6145/2024, decided on 21st March 2025, just a few days back. Honorable Supreme Court of India observed that although delay can be generally condoned without sufficient explanation, but if the merits disclosed that there is some material, then it cannot be waived off or it cannot be thrown away merely on technical grounds of the limitation. So, normally at the time of interpretation, I started with the legal maxim. Interest Republica ut sit finis litigium. In the interest of the state, there should be an end to the litigation. One case, one judgment is enough. But there are times, of course, it applies to the suits, but for the appeals and applications, Section 5 of the Limitation Act says, you are able to convince the court that there is inordinate delay due to this reason, yes, it can be accepted. Now, coming to the facts of the case, this is a case between the government of Madhya Pradesh and an individual. So, Inder Singh, he claimed ownership right over the suit scheduled property located in some village Mohi Rai. In survey number 8/1, he is having 1.6 hectares of land, and this land, as per the government rules, that is Madhya Pradesh government, they say it is grazing poramboke. They wanted to allocate it for public purpose. When it is a grazing poramboke land, the government has got the power of eminent domain, and they can alienate any land. Here, since it is a grazing poramboke, they wanted to go for some public purpose, but this man says it is his land. Therefore, he approached the Honorable Court, PSJ Court, and filed an OP 7/2013, series of litigations up to High Court. They supported the plaintiff. They said that since he has got the so-called patta, and also since he was given loan, he took bank loan also. It is his property. The government cannot come over his property, and they have given the judgment. Agreed by this, the government has gone for review, not allowed, and ultimately now they filed a petition or appeal petition before the Supreme Court. You know the delay is 1537 days. ఎన్ని సంవత్సరాలు మీరు లెక్కేసుకోండి, దాదాపు 5-6 ఏళ్ళు అయి ఉంటుంది. 4 years guarantee. After 4 years, they filed the belated appeal. That too, it is the second appeal. So, normally dismissal. కానీ సుప్రీం కోర్టు దగ్గరికి వచ్చేటప్పటికి number 1, it relates to the government. Government says it's poramboke land. No doubt government lands are encroached, they are being misused by so many civilians. We cannot let loose them. There is an important point that the land belongs to government. If the government is the owner of the land, yes, definitely they can utilize in their own way. If the government is satisfied, they can use it for the public purpose. So the general public cannot claim a right over the property. Of course, there is some mistake that has to be rectified. The judgment has to be delivered. It should be looked into very seriously, very keenly. So therefore, even though there is a delay of 1537 days, so here Asanuddin Amanullah, Honorable Justice, he said, while delays should ideally be not allowed, while delays be ideally not excused, but without sufficient reason. So the technical ground of remittation should not be used to undermine the merits of the case. There are some merits of the case. So basing on the very famous case law, Ramachandra Shankar Devdhar versus State of Maharashtra, 1974. The court said, allow. So the limitation period or the delay is condoned and government is allowed to submit its arguments in the second appeal. So very positive view by the Honorable Supreme Court of India. So this is the case. Please remember, sometimes even though abnormal delay will be accepted by the honorable courts. If you know this much, it is sufficient. Thank you.